am Dr. Satish Jagtap, working as Assistant Professor in New Arts Commerce Science College, Ahmednagar, in the Department of Business Administration. This topic, copyrights, is included in the certificate course of Intellectual Property Rights. We are going to talk on copyrights. In this session agenda, we are going to learn copyrights meaning and governing copyright systems in India, work covered under copyrights, duration of copyrights, copyright registration process, and infringement of copyrights. Before starting the actual contents of copyrights, I want to mention the definition of intellectual property, because copyright is a part of intellectual property. Intellectual property means the creation of human mind, like inventions, literary and artistic work, symbols, names, images, designs used in commerce. So whatever the intellect develops, that can be protected with the help of intellectual property rights. Mainly, intellectual property rights are of two types: industrial property and copyrights. In our day-to-day life, we see some things like tangible in nature and intangible in nature. Your car, refrigerator, TV, these are the goods which are come under the tangible things or tangible goods, and the services comes under intangible goods. So intangible, this intellectual property also comes under the intangible things. Just I mentioned IP mainly divided into industrial property and copyrights. Industrial property includes invention, trademarks, geographic indications of source, and another part of IP is copyrights. Copyright protects original creations such as musical compositions, property, art, films, computer, software, and website contents. And patents protect inventions such as new machinery, processes, chemicals, design of manufactured objects. So there is a difference between copyright, patent, and trademarks. All these comes under the intellectual property. Copyright is distinct from other forms of creator protection such as patents, which gives inventors exclusive right over use of their inventions, and trademarks, which are legally protected words or symbols or certain other distinguishing features that represent products or services. Actually, a patent protects the application of an idea, and trademark protects a device that indicate the provider a particular service or goods, and copyright protect the expression of an idea, whereas the operative notion in patents is novelty, so that a patent represents some invention that is new and has never been made before. The basic concept behind copyright is originality. Copyright represents something that has originated from a particular mind and not from other. Copyright, patents, and trademarks are all what is known as law as intellectual property. So the main focus is on copyright. So I am going to talk more on copyright. Copyright, actually, it is the right of copy, the legal right of the owner of intellectual property. Whenever a creator creates or writes a books, then his book can be protected by the Copyright Law or Copyright Act 1957. So copyright means, or copyright gives creation of literary, dramatic, musical, and artistic work, and producer of cinematograph, films, and sound recording exclusive rights to reproduce, perform, translate, and communicate their work to public. So whenever a particular author writes a book, or a musician plays his instrument, or artist draw a particular painting, then that work can be protected by Copyright Act, and he can distribute his rights to the neighbor, or you can say to the other persons. We call it as neighboring rights. So if a particular author writes a books, then to publish that particular books in the form of hard copy, or you can say a book, then he can give a rights to commercial publisher. If a particular filmmaker produce a film and he want to publicize it into the public, he may give rights to the another person, or a particular for a song, a recording studio can be used for giving the rights. These type of rights are called neighboring rights. So copyright law prohibits the unauthorized duplication, adaptation, or distribution of a creative work. So which type of work subject to copyrights? Mainly copyrights covers audio-visual work such as TV shows, movies, and online videos. It also includes the sound recordings and musical compositions, written books such as lectures, articles, books, and musical compositions, some visual work such as painting, posters, and advertisement, video games and computer softwares, dramatic work such as plays and musicals. Ideas and facts and processes are not subject to copyright. Copyright law, in order to eligible for copyright protection, must be creative and it must be fixed in tangible medium. And titles are not by themselves subject to copyrights. So, suppose a particular book written by author, you can't protect the title of that particular book under the copyrights. So moral basic behind copyright is that the owner of copyright holder has got certain rights and which are protected by laws. So copyright is the ownership of intellectual property within the limits prescribed by particular nations or international law. In the United States, for example, the copyright law provides that the owner of property has the exclusive right to print, distribute, and copy the work, and permission must be obtained by anyone else to reuse the work in these ways. So copyright is provided automatically to the author of any original work covered by the law as soon as the work is created. The author have the formally registered the work, although registered copyright is more visible. So when you purchase a particular property, you registered it at appropriate level. Suppose you purchase a car, you register that particular, you make the registration of that particular vehicle or car at a particular office or appropriate officials. So it gives the owner right of that particular property. So similarly, when you write a book, when you sing a song, that can be protected by copyright, or it gets protected by copyright law. So in India, there are some acts related to patent, copyrights, and trademarks. So the Patent Act 1970, for copyright, the Copyright Act 1957, and for trademarks, the Trademarks Act 1999. So these three acts are important from intellectual property rights point of view, and we are going to see the contents of Copyright Act 1957. So before that, I want to mention here duration of intellectual property rights related to copyright, related to trademark, and related to patent. So the life of this particular copyright is actually the life of author who created that particular property plus 60 years counted from the year following the death of the author. So this is the duration of copyright. And for trademark, the trademark is granted for lifetime but have to be renewed after every 10 years to prevent expiration. And for patent, 20 years from the date of filing of patent application. So here the copyright having the maximum duration for or the copyright has given a more years for protection purpose. So the Copyright Act 1957 is very important under the intellectual property rights. Generally, the copyright protection doesn't require registration. It starts from the time the work is created. However, registration of copyright provides certain advantage. One of the most important advantage is that it gives rise to presumption of ownership of the copyright and therefore gives the owner the right to sue an infringer in the court of law. So this, if anybody violates the law, then the owner of that copyright can sue against the violators. The register of copyrights is prima facie evidence of the particulars entered therein and documents supporting to be copies of any entries therein. The Copyright Act 1957 extract therefrom certified by the Registrar of Copyright shall be as evidence of all courts without further proof of production and original. So, the relevant provision of Chapter 10 of the Act related to registration of copyrights are as under. Mainly Section 45 includes the Register of Copyright, how to register the copyright that is mentioned under the Section 45. Section 45 entries in Register of Copyright. Section 45 consist indexes. So there shall be also kept at the Copyright Office such indexes of the Register of Copyright as may be prescribed. Section 45 covers forms and inspection of register. Section 48 covers the Register of Copyrights to be prima facie evidence. Section 49 correction of entries in the Register of Copyrights. And Section 50 consists rectification of register mainly by appellate board. Chapter 6 of the Copyright Rule 1958 as amended sets out the procedure of the registration of work, and that is also included in the syllabus, how to do the registration or process of registration. So application of registration is to be made on Form 4th, including statement of particulars and statement of further particulars as prescribed in the first schedule to the rules. Separate application should be made for registration of each work. Each application should be accompanied by the requisite fee prescribed in the second schedule to the rules, and the application should be signed by the applicant or the advocate in whose favor of wakalatnama or power of attorney has been executed. The power of attorney signed by the party and accepted by the advocate should also be enclosed. So Rule 16 of Chapter 6 of Copyright Rules included in this particular act, and that act is Copyright Rules Act 1958. Rule 16 of Chapter 6 of Copyright 1958 in the Section 22 terms of copyright in published literary, dramatic, musical and artistic work. Except as otherwise hereinafter provided, copyright shall subsist in any literary, dramatic, musical or artistic work published within the lifetime of the author until 60 years from the beginning of the calendar year next following the year in which the author dies. Section 25 mainly consists terms of copyrights in photographs. Section 26 of the Act consists term of copyright in the cinematograph films, and Section 27 terms of copyright in sound recording. Another important point in the copyright is the infringement of copyright. So we'll see the first meaning of infringement. Copyright infringement, or you can say copyright violation, is actually the unauthorized or prohibited use of works covered by copyright law in a way that violates one of the copyright's owner's exclusive right, such as the right to reproduce or perform the copyrighted work or to make the derivative work. The reproduction of literacy, dramatic, musical or artistic work in the form of cinematograph film, which film will be deemed to be an infringing copy. If a particular person try to make a copy of the literary work or musical work or artistic work without the permission of the creator, then the creator can sue against the violator and he can be punished according to the law. So copyright infringement is actually copyright violation, and it is without the permission of creator. The his work is produced in another form, is produced or copied in another media or another way, then that comes under infringement of copy. So what do you mean by literary, dramatic or musical infringement of literary, dramatic or musical work? For literary and dramatic work, the acts restricted by the copyright are reproduction, publication, performance in public, broadcasting offer for sale of records of the work, adaptation or doing of the aforesaid act to an adaptation. For musical work, the acts restricted are similar to those for literary and dramatic work, except that adaptation means arrangement or transcription of the work. For artistic work, the act restricted by copyrights are reproduction, publication, inclusion in a television program. So this is all about the copyright meaning, the act governing the copyrights, infringement of copyrights. Thank you.